Okay, so we will move on to Ethan Ruiz versus the state of Florida. And then following this, we will take a short break for a panel change. Council, whenever you're ready.
I am Brian Hugo.
Is 5 minutes sufficient?
Yes, it is. My name is Brian Hugo. I'm representing Ethan Ruiz. I was not trial counsel. I'm appellant counsel. Mr. Ruiz was convicted of vehicular homicide in I think it's the Fifth Circuit, sitting in Ocala, for an event that took place on the 14th of April of 2016. The vehicular homicide charge was ultimately filed by the state some 8 months later on December 14th, 2016. We are challenging the denial of the motion for a judgment of acquittal at the conclusion of the state's case, and of course at the conclusion of the defendant's case.
If there was evidence that there was both speeding and racing, would you agree that that's sufficient to go to the jury?
Well, I think that it's fundamental to our appeal that...
That's a yes or no.
All right, if you'd ask that one again, and I'll
sure.
if I might explain my
answer. If there was competent, substantial evidence presented by the state in its case that your client was not only speeding, but was also racing, was that sufficient evidence to submit the case to the jury?
Yes, if the racing was taking place at the time proximate to the event which led to this young lady's death.
And what evidence is there that it was not taking place at that time?
If I can track the facts a little bit, maybe that will help us in answering that question. As I go through the record, as I went through the record, I was surprised to see how racing was being established by the prosecutor as a fact rather than as a result of factual statements that were made by the variety of witnesses who testified that they observed these events as two parties traveled southbound on Marion Oaks Boulevard in Ocala. Now, Marion Oaks Boulevard is a wide thoroughfare, 2 lanes in each direction. One of the witnesses indicated that there was a 55-mile-an-hour speed limit in that
I thought Mr. Bazell
area.
said it was between 50 and 55. I've never seen a speed limit sign that said it's between 2 miles an hour. Are we bound to accept his testimony, him being from Pensacola, rather than the testimony of the trooper who did the accident investigation who said it was 45 miles per hour?
I think that the speed limit was 45 miles an hour at one segment, okay? At another segment, perhaps further north, it was at the higher rate. But it was never made absolutely clear what the speed limits were as the cars progressed southbound on Marion Oaks Boulevard.
Wasn't there testimony from one of the troopers that speed was calculated at 90.99 at the beginning of the skid marks?
At the beginning of the skid marks, just before this car left the road.
Correct.
That's. I think we have to accept that, although I believe the methodology could have been questioned. I think we, for the purpose of appeal, have to accept that. that for a very brief period in time that was not observed by any witness who survived to testify at trial or could remember the events that took place on that day. The speed was calculated at being, let's call it 91 miles an hour.
Well, if you take Bazell's testimony, he said he was going 50 to 55 and these cars passed him. He thought around 20, 25 miles an hour, although he was a little equivocal on that. But so that puts the cars going around 70, 75 as they go by him. You're trying to ask us to reach the conclusion that they were no longer racing after they passed Bazell, but in fact their speed increased, if you accept Bazell's estimates, from 70 or 75 up to 90.
What I'm suggesting is that there was no proof offered by the state that they were racing after that point in time when there was a slight curve involved as they head south. These two cars pass Bazell. Okay, the two cars go out of sight. A brief period of time passes.
Seconds, right?
Well, Bazell said seconds, but there was no attribution of distance. What he did say was that he couldn't see what happened. So we have these two individuals driving at a rate of speed, because Bazell is testifying at that point in time the speed limit was basically 55, 50 to 55. I acknowledge that. They were supposedly driving at, according to the testimony of Bazell, I think he made reference to perhaps 20 miles an hour over whatever his speed was. Now, although that is speeding, that's not grossly over the speed limit.
But he was positive. He was sure they were racing. He was sure. He wasn't sure about the speeds, but he was sure they were racing. Wasn't
Bazell is a lay witness.
I'll ask you again. This is a yes-no kind of a time. Didn't Bazell say he was sure that those two cars were racing?
I think he did say that.
Okay.
I'll give you a yes to that.
You want to say he may not have been right, but that's his testimony. That's the evidence that was before the court.
I don't believe that that is the most significant event that occurs in the course of events that led to this girl's death. I think the most significant event occurs and is observed by this gentleman whose name is Howard, who I misnamed as Martin in my reply brief. But anyhow, his name is Timothy Howard. Mr. Howard is slowing as he comes up to the next intersection on Marion Oaks Boulevard. It may be called Marion Oaks Lane. He's about 1/10 of a mile away. He's traveling at a rate of speed of 40 to 50, I think it was. But he's slowing. Two events happen virtually simultaneously. He hears an explosion, what he describes as an explosion. He turns his head 45 degrees to the left. As he's doing that, he sees two things. He sees the RUIZ vehicle, where the passenger was the decedent. He sees the RUIZ vehicle against a pole or having just experienced a crash into this utility pole. At virtually the same point in time, he sees the other vehicle that was alleged to be involved in this race traveling between him and the vehicle that is plastered against this pole, going at an extremely high rate of speed past him. Now, this vehicle was described, and I think that we can accept the fact that this is the same vehicle. Black vehicle was new. It had some kind of an enhanced exhaust system. It was making a lot of noise. this was the same vehicle that was seen by Amari Williams when this series of events starts. So we're talking about the same cars.
Let's take a quick step back. Now, this court's ruling in State versus LeBron, where there wasn't racing, the court looked to excessive speed in addition to other factors. Let's talk about some of the other factors in this case as well. It was observed that the cars were zigzagging in one lane. Is that correct?
Within the lane.
Within the lane.
Yes.
That they were an arm's length apart.
That is true.
All right. And
This was, now, admittedly, not to contest your hypothesis here, but this was well north of the point in time when the crash took place. But there was zigzagging within the lane that was observed. There was some excessive speed. They were relatively close to each other.
And this was a main road, was it not?
This was a main road. This was not a residential area. This was.
There's a lot of entrances for business. There's discussion of.
There were some. Traffic was light. There is one fact that I'd ask.
5 o'clock in the afternoon, wasn't it?
It was just before 5 o'clock. But traffic was referenced in the record as being light. There were 3 witnesses that they were able to summon up in this extended stretch of highway. And one would expect if it were a crowded, not light traffic that you would normally experience in a rush hour situation, that there would be more witnesses to testify. But I want to get back to that point in time when Amari Williams is describing the behaviors of these 2 vehicles. The black vehicle, the one with the powered-up exhaust system, is...
Who testified which car had the powered exhaust? I thought it was uncertain. Maybe I missed something.
Ultimately, I believe it was Bazell. It was either Bazell or Howard that they were observed to have this loud exhaust system on this new vehicle.
I'm not sure. Maybe when you're down for your rebuttal, getting ready for your rebuttal, take a look at that. I'm not sure. I'm not saying it matters a lot, but go ahead.
Yeah. We do also have, in response to that question, we do have testimony from the appellant that his car was absolutely stock, that there was nothing added onto it. There was ample testimony about the hearing of this very loud added-on exhaust system. So I think we can, from 2 angles, we can come to the conclusion that it was the other vehicle that was equipped in that fashion. But what I want to get to is the assertion by Amari Williams that she observed the black vehicle apparently attempting to block the progress of the RUIZ vehicle, and also observing...
I think it was stated that the green vehicle, the dark-colored green vehicle, was attempting to overtake the black vehicle, not that the black vehicle was blocking the progress.
There was some blocking going on.
Okay.
But then the green vehicle, when it was unsuccessful in doing that, when the black vehicle took off, the RUIZ vehicle held back. So that is more of an indicator that the black vehicle was the aggressor here.
It was ahead by the time they got to Bazell.
By the time they got to Bazell, the RUIZ vehicle was just ahead of the black vehicle.
The RUIZ is the green vehicle. That's how it's described, correct?
RUIZ is the green vehicle, yeah. At any rate...
Counsel, I feel like you're making a lot of very fact-specific arguments that would have been very good below to convince a jury on the weight, the credibility, all of these issues. But I think what Judge Edwards kind of started with was the correct question. There was some evidence presented by the state that there was racing, whether it was good evidence or strong evidence or I mean, that type of thing might be questionable, especially in the trial court with arguments, but there was evidence presented. Would you agree with that?
I would agree with that. I would agree with that. I believe that this court must take a look at these events in two components. The behaviors that took place in the northern section of Marion Oaks Boulevard where this took place is one set of events. We have another set of events which take place after these vehicles pass Bizzell.
How do you know that? What witness testified that anything changed other than they went faster?
Because we hear that there was a dramatic increase in speed on the part of the black vehicle that resulted in the black vehicle coming obviously extremely close to the RUIZ vehicle. And
Testified to that?
Pardon?
Who testified to that?
Well, they were extremely close when these two cars passed Bizzell.
Right.
The simultaneous nature.
You don't want to talk about Bizzell. You want to talk about down the road. Who talked about anything down the road other than the Highway Patrol's reconstruction?
Howard tells us
Howard
that
heard the explosion. He didn't
heard
see,
the explosion.
He didn't see Ruiz
The
leave the
black
road.
car.
He didn't see Ruiz leave the road, did he?
he did not see
He didn't
Ruiz
see any
leave.
contact between Ruiz and the black car.
He did not. He did
Did
not.
you put, not you, was there any evidence at trial that there was debris on the roadway indicating a collision between the two vehicles? I didn't see it in the record.
There was no indication of any collision, that is to
Was there
say.
any paint transfer from one vehicle to the other? I didn't see that in the record.
The car,
Yes or no?
Ruiz
Was there-
vehicle.
Was there any?
No.
Okay.
Ruiz vehicle was not examined for those purposes. There were a lot of questions about mechanical problems that Ruiz may have suffered that caused the tires to suddenly deflate. And
It's kind of similar with going passenger side sliding first into a pole. That could also deflate the tires.
well, it could. The state just never presented any evidence that would refute I believe, the likelihood that the black vehicle got very aggressive and chased this other car off the road. Ruiz had no option but to
There's no
accelerate.
evidence in the record at all that he was run off the road intentionally by the black car, is there? I mean, what witness testified to that?
I think that we can only extrapolate from the facts that we know. And those facts are pretty clear that the black vehicle was immediately behind Ruiz. Ruiz went off the roadway. Ruiz had not lost control in any part of this driving behavior.
When Ruiz was behind the black car, he didn't try to pull off the road. He didn't stop. He didn't do anything like that. They continued with the race. Is there any testimony to say they did not continue racing? I looked in the record. I did not see it. If there is some, please tell me.
I don't think we can assume that the race continued. I think that the state has to present proof that the race continued.
Aren't we required to draw all inferences of the evidence against the defendant? Isn't that what the trial court is tasked with in a judgment of acquittal?
I think that that is the standard.
So then why are we to assume that the race was discontinued or the speed of contest or that the driving pattern
Because the
discontinued?
racing behavior was not such behavior that evidenced the wanton and reckless disregard. It was speeding, but it wasn't, if we look at any of these cases, and there's myriad cases about speed as a factor in the decision to find sufficiency of evidence for a vehicular homicide conviction. That level of speed is not sufficient. I would ask the court to consider that.
Counsel,
70,
you do only
75
have about
miles.
a minute left of time. Do you want to save that?
If that's all I have, then I'll save it.
Okay.
Thank you very much.
May it please the court, my name is Kaylee Tatman on behalf of the state of Florida. The trial court properly denied the motion for JOA below. In the light most favorable to the state, the evidence of the grossly excessive speed and racing behavior was sufficient to show that the appellant was driving in a reckless manner, likely to cause great bodily harm or death, as it did cause the death of the victim in this case.
Counsel, I believe, is making the argument that there was no evidence given by the state that there was racing at the time of the accident.
To that, I would point to the testimony of Mr. Bizzell, who testified that was the witness who testified that he was sure they were racing. And he also testified as to their behavior that showed that they were racing. And he lost sight of them, I quote, for like a second due to a curve in the road, and that when he saw them again, appellant's vehicle had already hit the pole. And then later in his testimony, he said that he saw the impact like a split second after it happened. I think in that split second, we know that he was accelerating into a curve, and that is what caused him to lose control of the vehicle and crash. Any speculation on the part of inferences and the evidence should be taken in favor of the state, a motion for judgment of acquittal. And so the trial court properly denied the motion. If you have no further questions, we ask that you affirm. Thank you.
No further questions.
Thank you, counsel.
Your Honor, I know you had asked me a question, and I did not write it down.
That's all right. It
Does this
doesn't
pertain
matter.
to Bizzell's observations of any sort?
About who had the noisy muffler or not, but that's all right. I don't think that's here nor there.
At any rate, I would ask the court to consider the record, consider the case law, which appears to be heavily weighted in to make a finding that the level of wantonness and willfulness was not achieved in a case of this and similar cases, and order a discharge of the defendant, the appellant. Thank you very much.
Thank you.
Thank you.
We'll take a short recess and return momentarily.